Good afternoon to those people joining this webinar this afternoon. I see the people are streaming into the auditorium, as it were. It's nice to see. Those of you who want to say hello, you can use the chat functionality. Always like seeing where people are from. So just say, this is John, hello from Bloemfontein. And we can see where everyone hails from. There we go. Hello, Cornelius. We don't know where you are, but hello. Some Cape Townians, Joburgers, hi Bianca, Cornelius, another Cape Townian, Dorp, welkom, East London, Cape Town, Joburg. Oh, I love seeing it. Welcome, everyone. It's 1 minute past 2. We're just going to give a few more minutes, a minute or two for the room to fill up. East London, welcome. Lisa, Belinda, Escort. All Cape Townians, Greytown, KZN. Oh, we've got a lovely broad spectrum here from all over South Africa. That's lovely to see. We will just wait till about 14:03 and then we will formally commence. More Joburgers, Somerset West. Hi, Marika. Welcome. Oh, it's nice to see. The benefit of technology. Here we are, scattered around the country and all the little strings brought together here on a Zoom webinar. There's Richards Bay. Hi, Connie. Maritzburg, Joburg. Bethlehem, Somerset, more Somerset West. Right, I think Angie from Joburg, Andy from Cape Town. Angie and Andy, welcome. Right, it's 14:03, so I think it's right that we start. Those that are still coming into the room will just miss the sort of formal introductions and the welcomes. But good afternoon, everyone. We've got a very tight for time this afternoon for a very big topic. So the room is filled up really quickly, and it just tells one a story about the relevance and concern that people have about this very topic. It's a really good turnout. So thank you so much to all of you, firstly and foremost, for attending. A little bit of housekeeping and admin. I specifically asked you to use the chat to say hello from Cape Town, like Rashida saying hello there. That's what that chat box is for, is just for the informalities, call it that. To the left of the chat box is the Q&A tab. If you have any questions during the webinar, please feel free to ask the questions there. They will be answered on the fly if possible. If we find that there are recurring questions, we might park them and address them at the end if there's a common theme that's running through things, but we will certainly try our level best to get to the questions as and when they happen. First and foremost, our two panelists today. I'm George Findlay, or three panelists. I'm George Findlay. I head up our corporate division at LexisNexis here in Johannesburg, and I'm joined today by Gavin Puerta, who will be presenting today. Gavin is our resident expert on our platform known as Lexis Deceased Estates, which is the winding up of deceased estates platform, but also as a qualified attorney, he comes with a lot of knowledge, and he's going to guide us through this world today of deemed property. We're also joined by another colleague of mine, Jamie Lee Lawrence. Jamie Lee worked at the Master's Office in Cape Town for a very long time, also a highly qualified person, and she will help us navigate through some of the questions as and when we go along. Another bit of admin. During the course of the webinar, Gavin will give us the heads up on that, but in the middle there would be a poll that will pop up asking you some questions. Please answer that poll. It is really important for us from a marketing point of view, as well as how we can help you point of view. There'll be another poll a little bit further down into the webinar as it is. So we have a lot to get through. It's a very difficult topic. And I read the other day, we all know this line that says the two things in life that we can't avoid, and they are death and taxes. And that is, of course, is a quote of Benjamin Franklin, for those of you who didn't know that, but I found that quite interesting. So, but it's become, um, in the ordinary speak, the two things that you can't avoid. And my goodness, today we're speaking about exactly those two things all in one go. We're speaking about death and taxes in one go, but more specifically about deemed property. And I thought in my mind's eye, it sounds more like doomed property than deemed property. But hopefully, Gavin is going to help us take the doom out of this subject of deemed property, that we don't feel too doomed when we look at this. Now, Gavin, it was interesting. I quickly opened our LexisNexis library here on my side, and I typed in just the keyword deemed property, and it popped up the sources, which means that the sources of material, things that one must look at. And this is your challenge for today. Just me typing in deemed property comes up Stein on capital gains tax, the South African Financial Planning Handbook, estate planning, an outline of estate duty liability, the Estate Duties Act, the Administration of Estates Act, and even the Banks Act, Gavin. So there's an incredible amount. So thank you so much for taking the time and helping us navigate through this out of the mist and into the light of the concept of deemed property when winding up a deceased estate. Gavin,
Thank you,
I'm
George.
going to hand over to you, and I'm put my camera off, and I might interrupt you as we go along if there's something that I think we should maybe underline or highlight, if I may.
Perfect, George. I love some interaction and some questions every now and again.
Perfect.
Thank you so much for the introduction as well, and welcome everyone to our webinar today. As George mentioned, we'll be looking at deemed property, and hopefully we can give you a bit of a clearer picture of exactly what deemed property is and how we deal with it in a deceased estate. So first up, let's just have a quick overview of what our discussion for today would entail. So I just skipped over there. So first up, we'll just be looking at a better understanding of what deemed property is. And for this, we'll be looking at the definitions of both property and deemed property in terms of the Estate Duty Act. We'll then be putting up a bit of legislative framework, like George mentioned as well. All of those things that we mentioned will also be accessible through our Lexis library platform, but we'll also briefly look at it in this session. We'll then take everything that we've learned from there and kind of give a nice summary of how we can identify the deemed property in our estate, and also what criteria we need to apply to be certain that it's deemed property and not just normal property in terms of the estate. Lastly, we'll then also look at the estate duty implications we have when we're dealing with deemed property. How does this alter the calculations in our estate duty? And lastly, we'll also look at some practical examples where I would also showcase our Lexis Deceased Estates product and how that can simplify the way we deal with deemed property. Okay, so let's get started on a better understanding of deemed property.
Gavin, George here. Sorry to interrupt you so early on. You're not sharing yet on my side. So if you were sharing your presentation.
Okay, let me just reshare it from my side. Apologies for that, everyone.
There we go, Gavin. I can see it now. There we go. It's on full screen. Yes, you can carry on. We can see your first slide, Gavin. Thank you.
So I've just went through our topics of discussion for today, and then we are moving over to our first slide, which deals with a better understanding of deemed property and also helps us differentiate between what's property and what's deemed property for estate duty purposes. So first up, you can see that in the Estate Duty Act, we've got a very clear definition of the estate property. And it states that the estate property consists of two things, which includes our property, as well as any property deemed to be property in terms of the Estate Duty Act. Okay, so from this outset, it's not very clear what the difference is between the two, but we know that there are two different types of property that we need to be able to identify. Okay, so the first type, like I had mentioned, is property, and the second type is property deemed to be property. What is the difference between these two types of property then? Okay, first up, let's have a look at normal property. So normal property would be all of the property that forms part of the deceased estate at date of death. And then we go a step further and we also say that this property has a value before date of death. Okay, so this will be normal property in the sense of the Estate Duty Act. And all of this property forms part of our deceased estate. Okay, how do we differentiate deemed property from this? Deemed property, then quite the opposite, comprises property that becomes property of the deceased at date of death or because of the death of the deceased. Okay, so here we're dealing with property that doesn't necessarily form part of the deceased estate up until the day the deceased passes. Okay, and then that property also acquires its value. Okay, so our first main difference is that normal property will have a value at date of death and will form part of the deceased estate at date of death, where deemed property will only acquire its value as a result of the death and only form part of the estate as a result of the death of the deceased. Okay, so we'll look at some examples on slides later on, but referring to property here like donations made mortis causa, which referring to property like insurance policies on the life of the deceased, all these kind of properties that don't really form part of the deceased estate and don't acquire value up until the day that the deceased passes. Okay, so also important to note with deemed property, like we've mentioned, it doesn't really form part of the deceased estate. It's typically payable to a third party or transferable to a third party. Okay, why is it important that we have this distinction? Because we need to understand why property that doesn't necessarily form part of the deceased estate is included for estate duty purposes. Okay, so the Estate Duty Act purposefully created a deemed property section so that the property that's being transferred to a third party or payable to a third party is still brought to account for tax purposes. So we label it as deemed property, and then we specifically include a section for deemed property when we do our estate duty calculation. Okay, so now that we have a better understanding of exactly what deemed property is and how we differentiate that from normal property, we can look at our specific sections in the Estate Duty Act. And you'll see from the wording that they use in the Estate Duty Act that it's sometimes difficult to establish exactly what the requirements are for it to be considered deemed property. Section 3 of the Estate Duty Act does, however, very nicely put out 4 main categories of deemed property for us. So we've got subsections A, B, C, and D, which puts out these categories for us very nicely, even though the wording is somewhat difficult to understand. Okay, if you want to see the full legislation or you want to see the case law that I've mentioned at the bottom there, like I've mentioned before, we have our Lexis library, and specifically we have a section on trust, wills, and estates. And like George mentioned, if you put in the keyword deemed property there, then it will give you all of this important legislation as well as the case law and textbooks that pertains to the topic. So I'm going to ask Nadira just to pop up our poll right here. And I think the poll will ask you if you are interested in being contacted with relation to our library product, which deals with deceased estates. You can just indicate there that you'd like to be contacted. Okay, while the poll is up, I'm just going to run through some of the most prominent case law as well. So as you can see at the bottom there, I'm referring to 2 cases. Okay, so the first one we have is Makabela versus PPS Insurance Company. And here the court was specifically dealing with subsection A, which is our life insurance policy. And the question that was posed to the court here was, what happens if the beneficiary nominated in the life insurance policy predeceases the deceased estate where that policy becomes payable? Okay, so the court found here that on the death of the beneficiary, the nomination form was no longer valid. This was, however, taken on appeal, and the appellate court then found that even though the beneficiary in terms of the nomination form was predeceased, the contractual obligation still remained, as there was an agreement between the insurance company and an acceptance by the beneficiary on the date that they signed the nomination form. Okay, so in this instance, the court then found that even though the beneficiary was predeceased, they would still be entitled to the benefit from the life insurance policy, and it would have to go into their deceased estate. Similarly, we had the case of Peterson versus Shrosby, and here we were dealing with an insolvent beneficiary. And based on a similar conclusion, the court also found that a contractual obligation came into play, contractual relationship came into play when the beneficiary nomination form was signed by both parties, and therefore the beneficiary's trustee in the insolvent estate still received the benefit on behalf of that beneficiary. Okay,
Gavin, George, I just want to ask quickly, you say it's a contractual obligation there between the beneficiary and the person whose policy it was, the deceased. In your experience, I mean, does the beneficiary sign the acceptance form, or is it sufficient that the nomination is purely from the side of the deceased?
So that's also something that they touched on in this case law, George. So it's not necessarily a requirement that the beneficiary actually signs the the nomination form. So just the fact that the beneficiary accepts the benefit and doesn't dispute the benefit is enough to establish that contractual relationship between the beneficiary and the insurance company, even though the contract really only comes into being at the death of the deceased.
Yes.
It's still a contractual relationship between the insurance company and the beneficiary nominated in the deceased policy nomination form. So even though it's the deceased that signs that nomination form,
yes,
the benefit needs to be accepted by the beneficiary nominated therein.
And in that first case, the acceptance was actually the estate of the beneficiary accepted that benefit. Am I right?
That's correct, George. And also the fact that they had an opportunity to dispute the nomination, which they never did, and that became acceptance.
Yeah, so that's okay. Interesting. Thanks, Gavin. Yeah.
Pleasure, George. So now I'm going to move over to the next slide, where I'm going to try and simplify what we've just seen in the legislation and the case law. So what I've done here is I've taken 4 categories of deemed property. Like we've seen, it shows up in our Estate Duty Act, and I've taken all the requirements that you need to meet in order for that specific type of property to be deemed property. So let's look at the first one, which is subsection A, which is our life insurance policy on the life of the deceased. Okay, so any life insurance policy on the life of the deceased will be considered deemed property, but there are additional requirements that need to be met in order for it to be considered deemed property. Okay, so firstly, the life insurance policy needs to be a domestic policy in terms of the Insurance Act. So for this, you'll have to consult the Insurance Act and see if the policy is deemed a domestic policy. In most instances, you'll find that a life insurance policy that is from a local South African company does form part of the definition of a domestic policy. So in most instances, you will meet that requirement. The second requirement we have then is that the policy needs to be on the life of the deceased. So that one's quite straightforward. The policy needs to be taken out on the life of the deceased. The deceased does not necessarily have to pay the premiums for the life policy, and he also does not have to be the one who takes out the policy, but the policy needs to be on the life of the deceased. And lastly, also a very important aspect of the definition of a life insurance policy as deemed property is that the amount recoverable in terms of the policy cannot exceed the amount of premiums paid by a beneficiary if beneficiary paid any premiums. So this is important because we have a subsection in the Estate Duty Act, subsection 33A, which allows for a deduction on the value of the deemed property where the premiums were paid by the nominated beneficiary or any other beneficiary in terms of the policy. Okay, so the deduction here we'll look at when we deal with the calculating the estate duty, but it's important just to note here that the value of the policy can't exceed the premiums paid by a beneficiary if the beneficiary paid any premiums at all, Of course, if the deceased paid all the premiums, then this condition would have been met. Okay, also important to note here, there is sometimes a bit of confusion around whether this only covers insurance policies. So there was a amendment to the legislation where they clarified this standpoint. On the 1st of January 2009, there was amendment to the Estate Duty Act, which made it very clear that fund benefits, including provident fund, pension benefits, and retirement annuities, do not form part of subsection A of the Estate Duty Act and would therefore not be considered deemed property. So when we are dealing with the first category, if the deceased died after the 1st of January 2009, we only look at life insurance policies. Fund benefits, pension funds, retirement annuities, those are dealt with as normal property. They are not dealt with as deemed property after the date of the 1st of January 2009. Okay, so this distinction becomes important when we get to calculating our estate duty, because you'll see when we deal with deemed property, unlike our normal property where we have our deductions in terms of Section 4 of the Estate Duty Act, with deemed property, we don't have those same deductions. So we have a separate set of deductions that we are allowed to deduct from our deemed property value when we calculate our estate duty. Okay, but that then overview of our life insurance policies. Next up, we look at donations mortis causa, which is our second category of deemed property. So this one is quite straightforward. So the donation made in anticipation of the death of the donor will always be considered deemed property. So this was also something that was very prevalent in practice, where we had a lot of people that donated most of their property when they anticipate that they would be dying possibly soon. They would donate all of their property in order to try and avoid paying estate duty on that property. And what the Estate Duty Act then did is it created this specific subcategory of deemed property for donations made mortis causa to ensure that the value of that property is brought into account when we determine our estate duty.
Gavin, George here, will you be looking at some examples for us regarding this?
Yes, George. So at the end of our slide deck, I will be going through some practical examples, and then I will also show you guys how we deal with these types of deemed property in our Lexis Deceased Estates product, as well as how we deal with it on an L&D document.
Okay. I just see also there are some questions that have come in just about that third bullet point at the top there regarding the premiums that were paid by a beneficiary.
Yes.
Will you be looking at that again, just as a refresher?
Yes, I will. So I'll be looking at exactly how we calculate that Section 338 deduction, and I will also be looking at a practical example once we get to our end of the slide deck. Okay,
and then just one last question from me on this slide here. If you're speaking about donations mortis causa, so those were donations made before the death, obviously by the deceased. Do you touch on donations tax as well?
So not in this session, George, but that's quite an interesting topic that we might have to discuss in one of our upcoming webinars.
Okay. Thank you very much, Gavin.
Thanks, George. Okay. And then next up, I'm going to look at our third category, which is our accrual claims. So here again, we have some additional requirements that we need to take into consideration when we are dealing with accrual claims. So we have two types of accrual claims that we look at in this instance. The one will be as a result of a divorce, and the one will be as a result of death. So this is the dissolution of the marriage. So if the marriage is ended by death, then of course, the value of that accrual claim will be as a result of death, and it will only form part of the deceased estate after date of death. And as we know, that perfectly fits the definition of deemed property. So in order for the accrual claim to be considered deemed property, the marriage needs to be dissolved as a result of death. Of course, it wouldn't matter to which side the accrual is payable. Either it would be a claim in favor of the estate if the accrual benefits the deceased, or it would be a claim against the estate if the accrual needs to be paid by the deceased. Okay, so that doesn't really matter. All that matters is whether the marriage was dissolved as a result of death or as a result of a divorce. Of course, if it's dissolved as a result of a divorce, then the claim would have been there before date of death, and it would have had a value before date of death. So there we won't be dealing with it as deemed property. So it's important that we establish whether the marriage was dissolved as a result of death or as a result of divorce. Lastly, we also have quite a straightforward category. It's property over which the deceased was immediately prior to his death competent to dispose of for his benefit or the benefit of his estate. Okay, so this is quite simple to understand. There aren't any loopholes or anything that we have to look at here. So this refers to any property that the deceased was entitled to but had not yet formed part of his estate. So if we're, for example, looking at the transfer of a property, if there is any, if all the transfers conditions have been met and it just has not yet been registered in the name of the deceased, obviously the registration will only take place after date of death. We will consider it a deemed property, even though the asset doesn't form part of the deceased estate at date of death. Another thing we look at here is we can look at limited interests in property. We can look at title conditions, which kind of have a result that the property reverts back to the original owner. So all of those kind of things where the deceased was competent to dispose of that property, even though it had not yet formed part of the deceased estate, will still form part of our estate duty section of his estate or her estate. Okay, so now we've identified the four main categories of deemed property we have, and as well as the additional requirements that need to be met for them to be considered deemed property. Now, what are the consequences of this deemed property when we get to calculating our estate duty? Okay, so the two main ones we need to look at is our life insurance policies and our accrual claims. Okay, because they have they kind of go off par with our general rule. Our general rule is that all deemed property will be included in the estate, and on our estate duty portion, it will also be listed as deemed property, which is the second category in our estate duty account. So we won't list it together with our normal property. We'll list it separately as deemed property, but as a general rule, it will also be included in our liquidation account. There are, however, exceptions to this, where in some instances, it won't be included in our liquidation account, but only brought into account for our estate duty purposes. And the first instance we have for this is for our life insurance policies. Okay, so like I've mentioned, the life insurance policies need to meet all of the requirements in terms of the Estate Duty Act. So it needs to be a domestic policy, and it needs to be on the life of the insured, and then it needs to go one step further for it to be excluded from our liquidation account and included in our estate duty account. It also needs to have a nominated beneficiary. Okay, when we have met those three conditions, then the life insurance policy will not be included as part of the deceased estate, and we won't include it in our liquidation account at all. We'll only reflect it in our estate duty account so that it can be brought into account for tax purposes. Okay, here we're going to use the fair market value of the policy because it is payable because of the death of the deceased. Of course, if it's payable before the death of the deceased, then we're going to use the surrender value of the policy. But for purposes of this session, we're just going to be looking at the fair market value. And like I've mentioned, we will only include that in our estate duty section. So like I previously mentioned as well, our Section 4 deductions don't apply to our deemed property. Those only apply to our normal property that we've defined in our first slide, but there are certain deductions allowed from our deemed property. One of them is our Section 33A deduction. And this deduction states that when we deal with a life insurance policy, where we have a beneficiary that paid any part of the premiums towards that policy, we are allowed to deduct the full value of all those premiums paid, plus 6% per annum on the value of the policy, the proceeds that were paid out from the policy. Okay, so if we have a life insurance policy in terms of Section 33A, we have premiums paid by the beneficiary. We deduct the full value of all those premiums paid by the beneficiary, and then we also deduct a further 6% on the total value of the proceeds received from that policy. And that then is deducted from the value of our life insurance policy before we reflect it in our estate duty account. Okay, next up is our accrual claims. So here we've made the distinction between accrual claims as a result of death and as a result of a divorce. Okay, so first up, let's look at our accrual claims as a result of death, because then we know we're dealing with deemed property. Okay, where we have an accrual claim against the estate as a result of death, then we reflect it as a liability in our liquidation account and as deemed property in our estate duty account. Okay, so even though we do reflect this accrual claim in our liquidation account, it does not form part of our property per se in our estate duty section, but we list it separately under our estate duty account. Okay, the same kind of way we deal with it, the same kind of way if it's a claim in favor of the estate, okay, where it's a value that needs to come into the estate as a result of the accrual, then we might list it as a claim in favor of the estate. And even though that value is listed in our liquidation account, it does not form part of our property in our estate duty section, but rather as part of our deemed property. Okay, again, I'm just highlighting there that it's important to know the difference why we list certain assets in our deemed property section and certain assets in our normal property section. That's because the value in our normal property section, we have allowable deductions in terms of section 4, where our estate duty section, we don't have these same allowable deductions. We only have the one that we referred to above, which is section 3.3a. Okay, and then obviously, if the result of the marriage dissolved as a result of a divorce prior to the death of the deceased, then we'll deal with it as normal property. So we'll reflect it in our liquidation account either as a claim in favor of the estate or a claim against the estate. And here we will be able to deduct all of our allowable deductions in terms of section 4.
Sorry, Gavin. There is a question with regards to accrual claims.
Yes.
Should the spouse reject the accrual claim owed by the estate, does it count as a donation to the estate?
So that would come to a repudiation of the claim, and then it won't necessarily be a donation of the estate. It just it would no longer be a liability in the estate. So we'll just deal with it as cash value in the estate. It won't necessarily be a donation. It will be a repudiation on behalf of the spouse. So it would be as if though that benefit never existed. If that answers the question.
Thank you.
Okay, perfect. And then we've also dealt now with the implications that we have on our estate duty calculations when we're dealing with deemed property. So now let's move over and look at a practical example so that we can see how this actually emanates in practice. Okay, so here we have an estate. We have John and Mary who have been married out of community of property. They're survived by 2 children, David and Sarah, and they are left with a certain amount of assets and liabilities that we need to administer. Okay, so there are a list of assets there and a list of liabilities. The important ones I've listed here at the bottom, which is our life insurance policy. And we have David as a nominated beneficiary. So here we know that we are dealing with a deemed property. We also have a family car that has been donated to Sarah. And it's a donation mortis causa. So here we also know we are dealing with a deemed property. And lastly, we have an accrual claim in favor of the estate. And this, we also know, if it was as a result of death of the deceased, will be deemed property. Okay, so first up, I'm going to take you through our product Lexis Deceased Estates, which has been designed to simplify these rules and by incorporating it into the system. So you'll see I've loaded these assets onto the system, and when I navigate to the system, you'll see the system does automatically pick up when we are dealing with deemed property, and it will mark the deemed property for you and correctly either include it in the liquidation account or exclude it from the liquidation account, and then bring it into account in our estate duty account. So I've opened up Lexis Deceased Estates now on my side, and as you guys can see, I've navigated to our liquidation and distribution account. If I move over to our assets section, I've preloaded all of the assets that we have in that scenario. But importantly, I'm going to look at our deemed property. So the first one we have is we have movable property. And here we have the city golf, the car that was a donation mortis causa. Okay, so on our deceased estates program, you'll see we've captured the details pertaining to the car. And at the bottom here is as simple as clicking it deemed property. And as soon as we check it as deemed property, it will run the rules that I've just explained that we require in terms of legislation. So then it will still include it in our liquidation account because we're dealing with the donation mortis causa here, and it did form part of the deceased estate on date of death. So we still include it in our liquidation account, but it was transferred in essence on date of death to the third party. So it doesn't technically form part of our property for for estate duty purposes, but it's considered deemed property for estate duty purposes. So when we're dealing with a movable or fixed asset that is considered deemed property, we still include it in our liquidation account. And then in our estate duty account, we list it as deemed property. Okay, next up we had our life insurance policy. So you'll see here I've added that life insurance policy as well. So with the life insurance policies, the system will automatically consider it deemed property if all our conditions are met. So you'll see I've labeled this as, I've selected this as a life insurance policy, and I've indicated that it's a domestic policy and that we have a beneficiary nominated in terms of the policy nomination form. If all three of those conditions are met, the system will automatically consider it deemed property. And as we've seen, when we deal with a life insurance policy or a life insurance claim, then it will not be included in our liquidation account. It will only be included in our deemed property section of our estate duty account. So the system will also do that for you automatically.
Gavin, George here, sorry to interrupt. So even though that policy has a benefit, the beneficiary, the son in this particular case, I see you mark it still as a claim in favor of the estate.
That's correct, George. So we still load it as a claim in favor of the estate. But like I mentioned, the system will run in the background that this should not be included as a liability. So when it produces the document, which I'll download in a bit to show you guys, it won't actually reflect this insurance policy claim on our liquidation account, but it will only bring it into account for estate duty purposes. So even though we still complete it here, the system does run it according to the rules in terms of the Estate Duty Act.
Okay, thank you. So I mean, as an example, above you had that F&B bank account, so that's a claim in favor of the estate, but that's not marked as deemed, and therefore it will still be in the ordinary liquidation and distribution account.
That's correct, George. So with that one, that is money that has formed part of the deceased estate, so that we bring into our liquidation account. But where our life insurance policy that's been paid to a third party, we don't actually bring into the estate account. It pays out directly to that third party beneficiary. If, however, we did not have a beneficiary nominated in our life insurance policy, then it would come into the estate and it would not be considered deemed property.
And the LexisNexis Deceased Estates platform automatically does that calculation for you.
It does all of that automatically. All you have to do is check the relevant checkboxes and the system does the rest automatically.
Super, thank you. Thanks.
And then lastly, we also have our accrual claim here. And again, if all the conditions are met, so if we have an accrual claim, the system will automatically consider it deemed property. And then it will also run the rules as we do for our accrual claim. So you'll see for our accrual claim where the rules are a bit different, the system will still list it in our liquidation account, similar to our movable assets and our immovable assets. It will still list it in our liquidation account, but when we bring it into account for estate duty purposes, it will be listed as deemed property and not normal property. Okay, so now I've shown you how simple it is to load the assets on Lexis Deceased Estates and how just by ticking one or two checkboxes, the system will automatically run the rules required to deal with deemed property. If I then navigate over to our estate duty account, here you'll see how those assets are then listed in our estate duty account. So we have our first account, which is our normal property. And here we've seen this is property that has a value at date of death and forms part of the deceased estates prior to up until date of death. And it will list all of those properties for us in our first section of our estate duty account. But you'll see, for example, even though we have listed the vehicle and we have listed the accrual claim as claims in favor of the estate and as movable property in our liquidation account, it is not listed as property in our estate duty account. Rather, it is listed as deemed property in our estate duty account. So in our estate duty account, it will then list our 3 deemed properties and bring them to account separately in our second account. What I do want to show you here is even if we have the deduction in terms of section 33A, the system will do that for you automatically. So if I navigate back to my assets, and on this life insurance policy, let's say David paid a portion of the premiums, we do have a checkbox here which states that the premiums, a portion of the premiums were paid by the beneficiary. If we check this checkbox, we can capture the premiums that were paid. So let's say he paid about 25,000 of the premiums, and then we click on save, and the rest of the calculation is done by the system. So when we get to our estate duty section, then you'll see it has included our deduction in terms of section 33A. When we go to our account view, so it will indicate our deduction in terms of section 33A as well when we go to our account view, and it will deduct that premium as well as the interest on the proceeds of the policy, and then it will give us the reduced amount. So even that calculation, there's no need for you to do it manually. The system does that automatically, but that's also reflected, that deduction is reflected in our second account where we deal with our deemed property. Our third account then deals with all of our allowable deductions in terms of section 4. And like I've mentioned previously, these deductions will only apply to our first account. It will not apply to the value of our deemed property account. Okay, here we have separate deductions in terms of section 33A. Okay, lastly, I'm just going to give you a view of our document and how this then looks in the document, and then we can look at some questions. Okay, if we then open up our document, you'll see on our liquidation account, we still list those assets as movable property. Here we still have the car that was a donation mortis causa, and we still have the accrual claim listed as property in our liquidation account. Okay, so this is because it still falls under the general rule that we listed in our liquidation account, but when we get to estate duty, this value is not included as property, but as deemed property. So we can't deduct our section 4 deductions from these values in our estate duty account. We then scroll down to our estate duty account, and here you'll see our first account will give us the value of our property, but you'll see it is reduced by the value of our deemed property in our liquidation account, and that value is rather added down here into our second account that deals specifically with deemed property. And in the second account, it also then takes off our allowable deductions in terms of section 33A, and then it calculates our estate duty for us based on the values we have in account 1, account 2, and account 3. And that then is a quick overview of deemed property and how we deal with this property in our estate. I think there is another poll for us to pop up if there is anyone who is interested in receiving some more information about LexisNexis estates and how it can improve the administration process. You are welcome to just indicate that on the poll, and then some of the consultants will reach out to you to give you some more information and to improve your administration process with the use of LexisNexis estates.
Gavin, thanks. While the poll is up, if I can just ask, I mean, there are some questions that have popped up, and the request that we just revisit the predeceased beneficiary on the life policy scenario. So let's look at your example here, and let's say the son, was it the son John, if memory serves me, is the guy who inherited, or at least was the beneficiary in terms of that policy. Assuming he was predeceased.
Okay, so let's assume that, so David was the beneficiary in terms of the life insurance policy, but let's presume that he was predeceased. So he had died prior to his father's passing, and now we still have this value in terms of the policy that needs to be paid out to David. So like I've mentioned, there is case law on this, and the specific case we are dealing with here is our Mkabela versus PPS Insurance Company, which is a 2012 case. And the finding here was that with a predeceased beneficiary, there was still a contractual obligation for the amount to be paid over to that beneficiary. So that contractual relationship doesn't necessarily exist directly between the insurance company and the predeceased beneficiary, but it exists between the deceased and the insurance company. But the deceased then nominates the third party on the beneficiary nomination form. And the fact that the third party does not dispute that nomination means that they've accepted that nomination. And on acceptance, there is a contractual relationship comes into being between the insurance company and the third party. Okay, so the insurance company will then have to pay out on the death of the deceased or the insured in terms of that policy to the third party. Okay, so the condition is that the claim only pays out on the death of the insured, but it will pay out to a third party. So the relationship then between the insurance company and the third party still exists, even if the third party is predeceased. And that value of that policy will still have to pay to that predeceased beneficiary's estate.
Okay.
So the value there was much discussion in the case law whether there's an automatic whether that relationship automatically ends on the deceased, on the death of the predeceased beneficiary or the third party beneficiary. And the court found there that because it's a contractual obligation, it still has to go into the deceased estate, the predeceased beneficiary's estate. Even if he was predeceased, it doesn't nullify that agreement. Even though it wasn't physically signed, it doesn't nullify that contractual relationship. It still exists even after the death of that third party.
Okay. Gavin, an important question. I mean, there are lots of executors in the room who make their daily bread out of this. Deemed property, the value of the deemed property, does that form part of the calculation of the executor's remuneration?
So see, that would depend on whether we include it in our liquidation account or we don't include it in our liquidation account. So like you've seen with most of our deemed property, we still include it in our liquidation account. And in those instances where we still include the value of the deemed property in our liquidation account, we charge the executor's fee on the full value of those assets. So then you can charge executor's fee on the value of that asset. But if we, for example, are dealing with an insurance policy with a nominated beneficiary, that is domestic policy, we don't include it in our liquidation account. Okay. So for that specific asset, we won't calculate our executor's fee on the value of that life insurance policy. We only account for it in our estate duty account, and we then don't calculate our executor's fees on that. So in most instances, we will calculate our executor's fees on the value of the deemed property as well. But for life insurance policies specifically, those are excluded from our liquidation account. So we don't calculate our executor's fee on that.
Okay, that's very clear. Thank you very much. So in your John and Mary example here, the life policy of 1.5 million is not included, but the other 500 is, the 300 and
yes,
200 are.
That's correct.
Okay.
And on the LexisNexis system as well, it automatically does that calculation for you. So it will know to include these two values when calculating your executor's remuneration, but it will exclude this value when calculating your 6%.
Okay. And maybe it's a little bit broader than this conversation now, but if I look at the family car donation that was donated to Sarah, is there a donations tax implication there for Sarah or for the estate?
So the tax comes into play when we add the value of the property as a deemed property to our estate duty tax. So the tax will be payable by the deceased, of course, via estate duty. Donation tax will be dealt with in terms of Sarah's estate when she takes ownership of that donated asset. But for the deceased estates, it will only be payable. The only tax payable would be the estate duty. That's why we specifically bring it into account for our estate duty.
Right. Thanks, Gavin. A number of questions regarding accruals and deemed property. Maybe we could just revisit that just for a second again, the accrual portion on the previous slide there. Yes, thanks, Gavin.
Perfect. So like with accrual claims, just to reiterate, it's very important that we distinguish whether the accrual claim was there because of a result of divorce or as a result of death. Okay, when it is as a result of divorce, then it's normal property in the sense of the Estate Duty Act. So then we deal with it the same way we would deal with any other claim against the estate or claim in favor of the estate. However, if the accrual claim is as a result of the death of the deceased, then the marriage dissolves as a result of the death, and that claim doesn't really exist at date of death. It only becomes a claim, it only becomes an asset or liability in the deceased estate as a result of death, and it only gains value as a result of death. Then we know we're dealing with an accrual claim that's considered deemed property. When the accrual claim is considered deemed property, then we reflect it still in our liquidation account, and then we bring it into account in our estate duty account as deemed property. So this means we won't be allowed to deduct our Section 4 deductions. If I can put this in practical terms, so in most instances, our liabilities will be considered an allowable deduction in terms of Section 4. And Section 4 also makes specific provision for accrual claims to be deducted from our estate duty. So however, if the accrual claim is considered deemed property, we do not allow for that deduction in terms of Section 4 on our estate duty calculation. So if it's as a result of divorce prior to death, we are allowed that deduction in terms of Section 4. However, if it is as a result of death and it's now considered deemed property, then we aren't allowed that deduction in terms of Section 4. So that's why we make the distinction between accrual claims that are considered normal property and accrual claims that are considered deemed property.
Okay. Thanks, Kevin. I'm jumping around a little bit. If I can go back to mortis causa donations, one of the questions here also is a time frame related to that. So let's look back at your example that you have of John and Mary's estate. John died, but he did that donation to Sarah of the car, the 300,000 Rand car, 2 years ago.
Yes.
What is the trigger that makes it a mortis causa donation?
So that's quite an interesting question. That's also part of why this section in the Estate Duty Act was introduced. So a lot of people were donating their assets in the hope to kind of no longer have to pay estate duty on those assets. And that's specifically why the provision was put into place. So there's no time frame on when the donation can be made. So even if the donation was made 10 years prior, the only trigger, the only important part of it is that the donation needs to be made in anticipation of death. So the ownership of the asset or the value of the money or whatever that's being transferred to the third party or the person that it's being donated to only takes place because of the death of the deceased. So that's the important part of that donation. It can be made at any time prior to death, but it needs to stipulate that it only passes ownership because of death. Then it's considered deemed property.
And the difference between that and a bequest?
So a bequest we would deal with in the normal sense as we usually administer an estate. So a bequest will be stipulated in the will as a bequest to a certain party, and then we would still bring it into account in our liquidation account. And when it's in our liquidation account, then we automatically include it for our estate duty purposes. Why this was introduced is because the asset was donated technically on date of death, because that's when the provision of that donation steps in.
Yes.
It no longer forms part of the deceased estate from date of death onwards. So that's why we bring it into, we specifically still include it in the estate so we can bring it into account for tax purposes. So ordinarily, if it's donated on date of death, it no longer forms part of the deceased estate and you wouldn't necessarily include it in your liquidation account. But this provision of the Estate Duty Act tells you you have to include it still in your liquidation account and bring it into account for estate duty purposes.
Yeah. One of the questions here is, so are there no circumstances in which an estate would pay donations tax?
So I'm not clear on that subject completely, but I do think it's something that we could bring up in a discussion in one of our upcoming webinars. I'm not too well versed on the donations tax, but that's something that I would also like to research some more, and then we can have a further discussion on that.
Now, I think it's a very interesting overlap is this question of donations tax and then this mortis causa donation. I must say, I'm also
Yeah, so in my understanding would be that if the estate receives a donation from any other party, then donation tax would be payable on that donation received. But
yeah,
the donation tax is payable by the person who receives that donation.
yeah. See, because they're sort of interesting debates here. I mean, it's in one of the questions coming up is also the question of when transfer of ownership effectively takes place. Let's say of this motor car of Sarah's in your example.
Yes.
If the father donated the car to Sarah and the car was registered in her name, which effectively is the transfer of ownership, does that still make it a deemed property?
Well, I
So,
mean, in that sense, it would likely be that the donation has been nullified by the transfer of ownership. So, like I've
yeah,
mentioned, the condition of the donation needs to be that transfer will only take place on date of death. So, if transfer had taken place before date of death, then obviously that condition isn't met. So then we don't deal with it as deemed property because it no longer forms part of the deceased estate and it's been excluded from his estate way prior to date of death.
yeah, yeah.
Yeah, but I do. I think on that question also, so it is important, like we've seen in our third section of our last section of the Estate Duty Act, so Section D. It's important to distinguish when the date of transfer is going to take place. So, like I've mentioned, if we are dealing with, say, for example, a fixed property where all the conditions were met, it was just about to be registered in the deeds office, for example, so the ownership was established, but it had not yet formed part of that deceased estate. It will only be registered after date of death if the executor elects for it to still be registered. That will be considered deemed property because it does not yet form part of the estate on date of death, even though the deceased has the competence to dispose of it or enjoy the benefit of it prior to date of death. Okay, this we also get on when we get like regressive rights or revisionary rights in title deeds, where, for example, the ownership reverts back to the developer after a set amount of time. So the deceased in that instance would still have the benefit of that asset, but it reverts, for example, on date of death. That would still be considered deemed property and brought into account for estate duty purposes, even though it no longer forms part of the deceased estate. So there are those nuances that you need to look at, and then it will become important what the date of transfer was.
Yes, yes, yes. Gosh, Gavin, this see we're a minute to go, so we're effectively out of time. But it is you've guided us out of the mist in a big way. But I think there's still some clouds brewing in the form of donations tax, the Matrimonial Property Act, which is also applicable. And I think certainly these are topics that we can address as well in future. But let me tell you, I'm impressed when I see your deceased estates platform doing those auto calculations in your estate duty there. I mean, when I saw the deduction of the premiums that were paid by that one beneficiary and then the interest calculated on the premiums that he paid, and all of that is done automatically. That was seriously impressive. I liked seeing that. Gavin, yeah, I think we're at the end. Is there something that you need to say in closing, Gavin, or can we close up?
Thanks, George. I think the only thing I'd like to add in closing is that I do like that we are getting all these other topics that people would like to discuss, and we are busy with a series of webinars where we'd love to discuss these topics. So keep an eye out in your inbox. If you see any upcoming webinars, please do attend them. We would love to discuss the other topics that you guys have preached in this session as well. Thanks, George. I'm going to give over to you to close up for us.
Yeah, thanks, Gavin. And I think what you've said now is really, really important. I mean, I see, I mean, to Shane, you've got some really good questions here, and we haven't addressed all the questions on the Q&A, but they have given us material that we realize that we need to share and make public in a big way. Really good, important, and thoughtful questions that there are. So thank you so much, everyone, for joining, and thank you, Gavin, and thank you, Jamie Lee. This has been super informative and exciting. And as you've seen, there are two sources that you can really look at and tap into. The one is LexisNexis's practical guidance. When I gave that example that I just typed in that word deemed property, and it gave me that wonderful list of the sources that we have access to from the South African, the planning handbooks, the Estate Duty Act, the Administration of Estates Act, estate planning, etc. And then on top of that, of course, the legislation, the donations tax, the Matrimonial Property Act, etc. And then lastly, to say, well, of course, then there's the Lexis Deceased Estates platform, which automatically calculates all of this for you. You capture the data, and miraculously at the end, it generates this L&D account together with the estate duty account. It is impressive beyond. Ladies and gentlemen, thank you so much. Thank you very much, Gavin and Jamie Lee, and we hope to see you at our next webinar very soon. Thank you, everybody, and have a good afternoon further.